Hello friends, how are you? Namaskar. Today I am going to discuss an important topic concerning prevention of corruption at cases. In the sad case at hand, the concerned accused persons had been prosecuted, ultimately convicted as per section 7, 13(1)(d) of PCA, and later on the conviction was upheld by Honorable High Court, and ultimately the accused person was acquitted by Honorable Supreme Court. So we have to understand the basis of theory, the basis of point, and how the concerned accused got success from Honorable Supreme Court of India. So everything is important. Please note down the same so that you could have effective notes and could contest your case on the basis of available material. Okay, now the judgment name is Aman versus State of NCT. Please note down the same. Citation is 2025 INSC page 618. Please note down it. Petition number is 2613/2014. Please note down the same. In the said case at hand, the concerned complainant had submitted a report to the concerned Anti-Corruption Bureau. He submitted that he went to the office of servicer and ultimately he communicated with the concerned appellant because he has to purchase the stamp. As we know that we are having certain value of stamp in the market, rupees 50, 100, 500. So this time the concerned complainant is of view that to purchase the stamp of rupees 10, he communicated with the vendor, means the appellant, and inter alia he demanded rupees 12 in place of rupees 10 concerning the said stamp. Rupees 2 is towards the bribe, and that's why the matter had been reported to the concerned Anti-Corruption Bureau. In the meanwhile, the concerned report had been verified, pre-trap proceeding had been commenced, and finally trap had been done and accused was caught red-handed. The case of prosecution, and ultimately the concerned accused had been charge sheeted as per section 7, section 13(1)(d) of PCA. Later on, in the course of trial, the concerned prosecution is totally succeeded to prove the case as observed by Honorable Sessions Court, and later on the appeal filed by the concerned accused had been dismissed by Honorable High Court, and later on the concerned accused moved to the Honorable Supreme Court for vindication of his grievances. We must remember that in the present case, the court observed that demand is sine qua non. But before proceeding further, it is to be noted that in the said case, there are two parts. In part number 1, the court had observed that the stamp vendors are public servant and they are duly covered under the PCA. In case the violation is proved, in that scenario, they could be convicted under PCA. So concerning same, you may read para number 68 of judgment. Okay, now got the point. And concerning remaining part, the court had propounded certain guidelines. So if we are able to understand the same, then we may easily contest the case. Okay, now so first point is that in the present case at hand, the primary attack of defense is that in the present case there are 4 persons who are termed as material witness by the prosecution. Number 1, complainant; number 2, TLO; number 3, punch witness; number 4, IU. The complainant turned hostile, punch witness never supported, and remaining witnesses are not the eyewitness. So in that scenario, there is no effective corroboration to the theory of prosecution. In absence of corroboration, it could not be said that demand is proved. So the primary attack of the consent defense is that it is a case of non-corroboration of evidences. Point number 2 is that to sustain prosecution of the accused person, demand is sine qua non, and demand is required to be proved by the prosecution. If demand is not proved, even though there is mere recovery, mere acceptance, the same cannot be a basis for prosecution of the accused under the PCA. And apart from that, there are certain material points which are important to be noted. In the present case at hand, the concerned complainant had hostile. Do you know when a concerned complainant hostile, it means the concerned report will not be corroborated. The concerned transcription, if any available, will not be corroborated. Apart from that, the pre-trap, the trap, and the other proceedings will not be corroborated, because in the case under PCA, the concerned complainant is the star witness, and if the star witness is inter alia turned hostile, in that scenario, the concerned accused could have the benefit before court of law, because in said scenario, there will be no active corroboration, and in absence of corroboration, we could have the benefit. Okay, now got the point. Now it is easier for us. Sometimes it is a strategy of defense, despite of having the hostile, the inter alia make the concerned witness unspecific, uncertain. The key point is that the theory of defense is that if the concerned witness, means the complainant, inter alia depose the statement that are inconsistent, mismatched, or there is omission or material improvement as compared to prosecution story. In that scenario, on the ground of inconsistency, the concerned defense could have the benefit, and such conduct is relevant as per section 145 of the Evidence Act. Do you know? But this point is quite important. And apart from that, if the concerned complainant means a star witness, if unreliable, then we could have the easy benefit in the court of law. So if the concerned complainant turns hostile, the concerned defense could have the benefit. It is a usual question asked by all of you or some of you, so I am going to answer the same by the help of that citation. And apart from that, the concerned defense is of view that the punch witness are not going to support the story of prosecution, because at the inception the statements are that inter alia he saw the conversation, inter alia he witnessed the proceeding, and later on in the court of law he submitted that he neither seen nor observed the proceeding occurred allegedly between the complainant and the accused person, and apart from that, currency note were not recovered from the person of accused, rather than it is recovered from the register on the table. So when the demand is not specific, the concerned punch witness is not giving the corroborative version, apart from that there is no recovery from person, and the acceptance theory is absent, and the alleged money is recovered from the register of the concerned accused. In that scenario, the theory of false implication could be pressed into motion, and the same is also one of the most important way to have the proper probable defense on record. Point number 3 is that the concerned defense supported the case by relying on judgment of Neeraj Datta versus State of NCT. Judgment citation is 2023 volume 4 SCC page 731. In that case, the court observed that if there is a voluntary acceptance of the offer of complainant regarding bribe, it is case of section 7 of PCA, and if the demand is made by the accused in lieu of certain benefits for himself or for his family or anyone in whom he is interested, then it is a case of section 13(1)(d) of the PCA. So the court specified that mere recovery of any money, mere demand, mere acceptance not sufficient. The demand must be specific. If there is no demand, or demand if asserted is not supported by corroborative evidences, in that scenario the concerned prosecution cannot be said to be succeeded. So the court emphasized on that point. Apart from that, we are having multiple judgments of Honorable Supreme Court. In all the judgment it had been specified that even though there is recovery from the accused, even though there is mere acceptance, but there is no specific demand, in that scenario the concerned accused could not be prosecuted. Okay now, so demand of alleged bribe is saying going on, and apart from that there are certain factors which are attributable to the concerning scenario. That is, the concerned accused must be a public servant. Being a public servant, he is having a pendency of work, and to discharge that work he has used the corrupt or illegal means. He abused the official position to provide undue benefit to the complainant, and apart from that he is willing to accept the amount, and he knows from the inception that the amount is bribe. If such ingredients are absent, and apart from that the factual score available on the record is not going to support the theory of prosecution, then we could have the benefit. And apart from that, if there is a material inconsistency in the case of prosecution, for example, the concerned complainant is having the different story, concerned punch witnesses are having the different story, concerned TLO is having its own story, so on point of inconsistency, omissions, modification, we could have the benefit. And apart from that, there are multiple queries from your side that section 20 of PCA would be applicable, so we could not be succeeded. I want to clarify that in the present case also Honorable Supreme Court specified that section 20 of PCA merely spell about presumption, and presumption is concerning section 7 of PCA, and it is not applicable for section 13(1)(d) of PCA. In the present case at hand, the case of prosecution is that rupees 12 had been demanded, so it is of two parts, 10 is genuine and 2 is illegal. Even though 10 rupees had been recovered, even though it is demanded, it is not a bribe amount. And as far as rupees 2 is concerned, so the prosecution has to specify that it is a bribe amount. And apart from that, the amount had been demanded by the concerned accused to exercise its official position in illegal way or by having corrupt means to provide undue benefit to the concerned complainant or anyone in which complainant is interested. So such specifications, such averments are absent, and apart from that there is nothing on the record to support all these things. So when the basic elements are absent, the factual scenarios are absent, the corroborations are absent, there is a major inconsistency in that scenario, we could have the benefit. In such scenario, no presumption could be drawn as per section 20 of PCA. To draw the presumption, the evidence must be specific and consistent, and apart from that, the prosecution must be succeeded to stand the case. If the case is not specified and there is nothing on the record to make the case more specific, in that scenario the concerned defense could have the benefit. So these are the important points for your kind perusal and notes making. So prepare your notes and have the comparative study of your case with that case. If you are having the same circumstances, then you could be succeeded and could have the benefit. So see you in the next video. Till then, Jai Hind, Jai Bharat.